show for you today on the second day of the baseball season, or maybe third day if you count that Yankees-Giants game where two of our teams were victorious yesterday. Um, but at the Supreme Court, a lot of exciting things. We had four oral arguments this week, a couple opinions, some interesting dissentals in the order list, per curiam opinion, and then we'll end today with a little trivia for two my two colleagues. I'm once again joined by senior attorneys at Pacific Legal Foundation, Damian Schiff and Oliver Dunford. Welcome, gentlemen. Well, let's get right into it. I thought the most exciting happening was the oral arguments, and in particular, I was really fascinated by the oral argument in Watson versus Republican National Committee. This concerns the meaning of Election Day, a statute that I think was written in the 1840s. Is that right, Oliver?
Something like that, but it's old.
Yeah, a very short statute, not a lot of subparts, but just says Election Day when Election Day is set. And the issue concerns what has become more common in the last 5 years post-COVID is ballots that arrive that were postmarked, or at least were submitted prior to the deadline of Election Day and arrive to the registrar or whomever is counting the votes after Election Day. And the question is whether that process that allows for states to count votes after Election Day is consistent with the statutory mandate that congressional elections are set on that first Tuesday of November. Oliver, what are your first sort of initial thoughts about the case, or maybe even you can start talking about the argument?
Well, I think the one thing that came through the arguments is that the federal statute, as you said, doesn't say much. And so then the question is, how much should the court look at history and tradition? And there was some discussion of the Bruin case, the Second Amendment case, which talks a lot about history and tradition, whether we should look to the Civil War history, and, kind of World War I history. And so then the question is, if this is a preemption case, they said, and so if the federal statute doesn't say much, then that must mean that the states are free to do whatever they want. That's kind of the basics. And then, or should Election Day be? And then I guess the question then is does the term Election Day mean Election Day? The votes have to be in, cast, and received by Election Day. And just as you said, the state exceptions to that, can those exceptions be allowed under the federal statute?
Yeah, and if I'm to summarize sort of like the first cut of arguments from both sides, I think what you noted about the statute being pretty bare bones is the argument for the petitioners here. So we should clarify, the Fifth Circuit here held unconstitutional Mississippi's, was it the 5th or the 11th? Where's Mississippi?
Mississippi.
Is that the 5th or the 11th Circuit?
I'm sorry, 5th.
Fifth Circuit.
Whether Mississippi's allowance of, they have 5 days that they will continue to count ballots after quote unquote Election Day if they were submitted prior to Election Day. And the Fifth Circuit held that unconstitutional contrary to the text of the statute. And the argument of Mississippi here is that, look, typically in these preemption cases, if it's not express, then it's not preempted. And given that there is a lot of leeway or there's no guidance in the statute, why not allow Mississippi the latitude to craft its policies in the way it sees fit? And I think the argument of the other side, the RNC and the Libertarian Party, I think was also a party here, is Election Day, and Election Day means Election Day. Everybody for the longest time has understood that term to mean a single day. And I think it was Alito, or maybe it was even the opening, said like, we have birthday, we have Labor Day, we have Veterans Day, we have George Washington's birthday. All of those mean a particular day. and yet we're going to say election day, which is also in the statutes, means this, week-long period that goes before and after. Thoughts on those two positions, Damien?
Well, I'd like to back up a little bit and say how strange it is that this issue would come up by the Republican Party challenging Mississippi's vote counting mechanisms. It just seems a very bizarre context. But I would say that the biggest problem for Mississippi here is, I think even really retracted or conceded, maybe is the better word, at oral argument, is about recall, because not voter recall, but the recall of your ballot. And Justice Gorsuch in particular, and other justices, asked the Solicitor General for Mississippi, what about the fact that if you give it to FedEx or the Postal Service, you have the authority to have it taken back? So simply because you've given it to that third-party carrier, does that mean that you've really voted and made a final decision by election day? And the State Solicitor General's answer was there would be a problem if recall were allowed, but he argued that Mississippi statutes didn't allow that. Now, there was some dispute as to whether that was a fair reading of the state statutes. On the other side, and this is something that Justice Kagan, I think in particular, emphasized, but just the Chief Justice as well, is there a problem with early voting? Doesn't that also seem to raise, maybe not the same sort of appearance of impropriety or fraud concerns, but it does seem to raise some sort of textual inconsistency concerns if you allow somebody to make an irrevocable decision before the actual election day. So I think by the very fact that Mississippi was not willing to defend the idea of third-party delivery with recall demonstrates that the court, I think, is going to be inclined to restrict the ability of votes to be received and counted after the quote-unquote election day. But as Paul Clement noted as well in his argument, this statute is not universal. It just applies to the federal November elections. It doesn't apply to primaries. It doesn't apply to, obviously, any state elections. So to some extent, it has a more limited impact.
Yeah. It was a surprise. I don't think we previewed this. Did we preview this last week? I don't think we did. And it was, somewhat of a surprise to me when it came up, and then it was even more of a surprise when Clement gets up there. And I feel like he's had 20 arguments this term. And once again, does a masterful job, as he always does. Yeah, I think there are two things that I want to respond to in what you had just noted, Damien. The first is this idea of recall, which Gorsuch really gave the business to Mississippi when the Mississippi lawyers' sort of primary defense was, look, whether or not recall's allowed or could be allowed is of no moment, since we don't allow it in Mississippi. It's flatly prohibited by our law. And so Gorsuch, walked him down the line to basically, he admitted that would be problematic if you could recall votes and change them, and ultimately that could swing an election if enough people did it. And then he asked the Mississippi council, where in your statutes or regulations does it prohibit this? And he's like, well, we just kind of understand it too, but it's not written there at all, and was really pretty direct in his questioning of the Mississippi council about its inability to point to anything written that would prohibit them or prohibit an individual from doing this. And if there's nothing written, then of course, why could it, how are they going to prosecute it and police it and all that stuff? All those things came up. So I thought that was interesting. I didn't frankly know you could recall things from the Postal Service. Did you know that? I thought once you put something in the post office that was that's why you can't tamper with mailboxes.
Right. I guess that's somebody else's mailbox.
Well,
right?
You can't recall through self-help, but the post office does have a process whereby you can request. I learned that actually in my contracts law class in law school.
Oh, it doesn't come from your philately?
No, not directly.
So you can just call up the post office and say, I mailed a letter. I want my Christmas card back that I put in the mail.
I mean, I think theoretically you can. I think practically speaking, that probably wouldn't be processed prior to the actual delivery of whatever you posted.
Right. So maybe it works better with certified mail or something like that.
Or with FedEx or UPS or what have you. Yeah, but at least theoretically, I think that is still the rule. Now, this is also something that came up in that questioning between Justice Gorsuch and the Solicitor General for Mississippi about, well, what about why does it have to be even a USPS official? Why couldn't it be like my brother Bob? Why couldn't it, or Justice Barrett suggested, what if the president of my HOA said, I'm willing to deliver everybody's ballots. What's wrong with that? And the response was, well, it has to be some sort of government official, it has to the sanction of government, which seems a little vague.
I thought he said that would be okay if it was authorized.
Well, I think that's his point, is that then they would become sort of like government actors.
Yeah, which
Yeah.
is right, which is strange.
Yeah.
But I think Clement's argument concedes that too. So they both, so there's sort of two issues going on here. It's like who can receive the ballots or who can deliver the ballots, maybe is a better, by election day. And then what is the date of election day? And on that second point, the like, who can deliver them, it didn't seem, it was hard for me to really distinguish between the various positions of the two parties.
Well, I think that that the question really is when it's delivered. So
Right,
if Clement was saying, and he kept going back to the Civil War, that during the Civil War they spent tons of money and resources to make sure that the ballots were cast and counted on election day. And so, yes, you could give them to your superior officers or something, but still, the superior officers somehow had to make sure they were received by the election
Yeah,
officials.
received, yeah, not counted, but received.
Well, it
I'm
was,
sorry, yes.
you could designate a proxy, I think, to physically vote for. I think the proxy would go to, maybe this is one of the rules, the proxy would go to the voting booth and vote for you.
But it was still done on that
It
day.
was still done on election day, right, exactly.
Right.
Yeah.
And now the reason that, or part of the reason that there was a dispute about that point, the Mississippi said, well, that doesn't prove that that's what the statute means. All that shows is that that's how elections were done at that time. All elections were cast on election day, and so that's just how they did it. They didn't, when they set up that system in the Civil War, they didn't do that because they thought they were under some obligation to actually have the votes received by election day. It's just how it was done at that time. I'm not about that argument either, in terms of the interpretation. One thing I did think was, Damien, you mentioned it was kind of a strange posture to have the Republicans challenging a Mississippi statute. Another thing that came up, I think it was Alito, who said, I think it was this case, but he said something like, well, shouldn't we look at the statute's purpose? So here's a textualist saying, well, I'm not sure that we need to look at that. What's the purpose of the statute? Again, maybe I'm confused. I listed all four arguments today, so I could be confusing it. But it was definitely Alito who asked the question, so I thought that was an interesting angle.
Yeah, no, I think you're thinking of the argument dealing with interstate transportation.
No, definitely didn't bring it up in that question, or in that case, but
Well,
it was Alito. Anyway.
I also thought it was interesting that there were at least 3 different amicus briefs that were the basis of specific questions from the bench.
Mm-hmm.
And two professors, and then there was another one. So I thought that was interesting. That seemed a little unusual to me that the court would have such interest in that, but it did seem prominent in this argument.
Yeah. Did you know that you could mail in your ballot through FedEx? I never thought of that.
Well, here in California, they actually pay the postage for you to mail in your
Yeah.
ballot. So there's not much reason. I don't know why you would want to pay for FedEx then.
I mean, California notoriously like doesn't give out vote counts until like months late. Like
Yeah.
they like trickle in, and so many. I mean, I've only voted by mail in California since I've lived here, I think. I don't think I've ever
No
gone.
longer have. I don't think you can actually. Well, maybe you can still.
No, there are definitely polling booths
Yeah, you
because
can still
at the
transfer.
ballet studio they have polling booths. But yeah, I mean, if this it does, I mean, let's cut to the chase. I think the Supreme Court is going to hold that election day, that votes have to be in by election day. I mean, the commentary I read and my take of the oral argument all seems to hint that, reading the tea leaves, there's a lot of skepticism that this policy of allowing votes to continue to be coming in post-election day violates the terms of the statute.
Well, and I also think that they can say, look, this is the history and tradition is that you cast the votes on election day. The exceptions are just that, exceptions. And in the most recent, the reason the Mississippi statute is at issue is it was adopted initially because of COVID.
Yeah.
Now, and some states that enacted similar laws have since repealed them. Mississippi, for whatever reason, still has that law on the books. And so I think as you say, I think the court's going to say that you have to do it on election day, and that we shouldn't allow this exception to set the terms of or to change our interpretation of the statute.
Yeah.
Now, why do you think that this is a partisan issue?
I was going to ask the same question.
Yeah.
Well, I mean, I think I don't know why it's a partisan question as opposed to as like the Republicans usually want the military votes, so they would want them to come in late.
And we should say there was a lot of discussion about military votes here.
But
Yeah.
but there's a separate statute that
Yes.
that handles that. So
Yes. But there's also, I think generally, although it's not true so much recently, but most of my lifetime, when the turnout was higher and absentee ballots in general supported the Democrats. But that's changed. I think in fact, I just read yesterday or today that if the turnout had been higher in the most recent presidential election, Trump would have done even better. But I know that historically it's true. So, and again, I think absentee ballots have generally helped the Democrats. And in fact, Clement, he always has some good lines. He talked about the polling places in Chicago stay open until midnight and others close at 8 p.m. And he said, now I would never suggest that there's any kind of fraud going on in Chicago elections or with elections in Chicago.
As a good Wisconsinite, Paul Clement never fails to take the time to give a good jab to Chicago, and I appreciate that.
That was good.
Yeah, that was great. Yeah, I only add that it strikes me that it came up in the oral argument a couple times that Washington has like a 28-day. Some like they'll accept ballots for 28 days and they don't have to be postmarked, and it's like, all right, at some point you're getting a little ridiculous in the votes you're counting. But at first blush, it never really struck me as a issue that I cared about because it never really struck me as swaying elections one way or the other. But I suppose there is some concerns over fraud, and I get that, especially with recent examples where politicians are complaining about that a lot, to have a date set. Maybe one last point on that was compelling to me is every one of these states is setting a date. Like Mississippi sets it 5 days, and if a ballot comes in after that, even if postmarked, it will destroy the ballots. And every other state has some date by which they will no longer consider ballots. So if that's true, then why not just make it election day? Right? And just to be fair, the other side's response to that is, well, some people want to wait and consider all the information up until, the Tuesday, which, okay, I think that's probably true. I think some people do sort of switch their minds on the last day.
But your
And-
point would be those people shouldn't be allowed to vote anyway, right?
Well, but that goes to the recall question too. If
Yeah.
you send your ballots in 2 weeks early and then some big sex scandal comes out or something, you say, well, I want to change my mind, and so you try
Yeah.
to recall your vote. It's the opposite side. So again, I think that cuts against
I'm not sure.
Clement's argument, saying that that's okay. Now, I think Clement was saying because that's just kind of an exception that's become accepted.
Yeah.
But it does cut against his argument, I think.
Isn't it kind of arbitrary though? Because I mean, let's say the scandal happens the day after Inauguration Day. Okay, well, too bad, so sad. Now you have to wait, 4 years or until you impeach somebody or what. I mean, so I'm not sure why that consideration should be particularly. I mean, it certainly doesn't justify undoing elections. So why
No,
would that?
right. I agree. I think it's just a timing question. If you vote a month early and then find out there's a sex scandal, there's still time, arguably, to cast your ballot because it's not election day yet. And on the other hand, is it how long afterwards can we keep counting these things? And does that could the post? Can you send stuff in after the deadline? If there's no requirement for a postage stamp, for example, or then you can arguably change your life. Who the hell knows? I don't
I mean,
think.
do scandals even matter anymore? We had
Well,
a
no.
president
And
who
how-
said grab him by the pussy like a day before the election, and it didn't matter.
And how much does any of what we're talking about? How much do these ballots actually have affected elections? Counting these ballots after, or accepting these ballots after they've actually affected. I don't know.
Well, that then goes to, our question about, I mean, presumably the entities who are in the best position to actually know whether this could affect, would
Good
be the
point.
political parties, and they obviously think that it's worth litigating over, so I
And it
wonder.
did feel like, for what it's worth, that the three justices appointed by Democratic presidents seem more sympathetic to the late voting for whatever. So maybe there's certainly a perceived partisan effect here.
Mhm.
Whether that is actually true, I'm pretty skeptical.
Okay.
Yeah.
Well, there's a couple of other good lines from Clement, though.
Oh, what else you got?
Well, at one point, you
Reddest of
mentioned
red
it
herrings?
before, with red hair, Justice Sotomayor brought up the 2020 election, and Clement said that with respect, that is the reddest of red herrings, and then proceeded to try to explain it to her. And then at one point, and this wasn't quite as obvious, but Justice Kagan was asking about his theory, and he said something like, "Your theory requires," and Clement said, after a little bit of throat clearing, said, "Well, it's my theory, so I'll tell you what it is."
Yeah, no, that was good. I saw that. Yeah, that was a good one. Yeah. He's always quick on it. I'm always amazed. Like, what is his? I would love to spend a month with him to figure out his preparation, because it's seamless, his transitions. I mean, there's some things that are obviously rehearsed. Reddest of red herrings was rehearsed.
Mm-hmm.
But some things he comes up with on the fly in response to questions that are just really special.
Yeah, well, not only that, but he seems, although today he did admit there were a couple of things he didn't know, but he said, I haven't researched that thoroughly, but I'd be willing to bet, whatever. But for the most part, he is fully prepared for the questions that come up, and and says, well, that goes to the whatever statute and the whatever case, and he's just, he's got just about. I mean, I think today, in fact, when he said I haven't researched that, I think it was the few times I remember that he didn't have didn't know the answer.
Yeah. Well, fascinating case. Certainly one of those ones. Well, there was some discussion of whether this can be implemented in time.
Yeah.
Let's say it comes out as one of the final opinions in June or July, and Clement had a ready answer for that, saying yes, shouldn't be an issue because this only applies, as Damien noted, this only applies to the November election and to no primaries. So.
Yep.
Let's move on to what I thought was.
Sorry, can I just add one more? We're talking about the BOMO from the argument for Clement. When Justice Sotomayor was asking about a prior decision, she asked, but the rule of decision was based on state law in Maddox, wasn't it? And then he responds by saying, I disagree. I mean, you can all read it for yourself. I mean, I know my friends on the other side say that. I've read the case 7 times. And then they move on. And yeah, I think that's part of, he's able to do stuff just because he has such an accomplished.
Well, I mean, that's also, he's probably right about. I remember that. And I'm like, well, I should go back. I wanted to go back and look at it in preparation for our talk today. I didn't, but he's probably right. It probably is ambiguous, and to have the cojones to tell a Supreme Court justice that, that's not what it says, and go back and read it. You can read it for yourself. But he does it. He does it. I mean, I think you can cross a line, but he does it in a way that he's like, no, honestly, I don't think it says that.
Well, speaking of crossing, earlier this term we had the what the statute is. Remember that line he had.
The taft.
Oh, yeah.
Oh, and one of the decisions that actually came down recently, the Cox case
Yeah,
concerning.
we'll talk about that in a little bit.
Yeah. So.
I thought the second interesting oral argument was Nome versus El Otro Lado. Oliver, what was this one about?
Well, this is about when people were seeking to come into the United States for seeking asylum. The statute says that someone who arrives, quote, arrives in the United States, where does that happen? And the United States in this case was checking people apparently inside Mexico. I don't know how that works, but the United States was processing people in Mexico. And so the question is, at that point, had they arrived in the United States? And then in the questions, I think all the justices were trying to figure out when or where that happens. So, for example, if you're in line, have you arrived in the United States? And I thought the petitioner in this case was the Solicitor General, and the case came up because the lower court issued an injunction and prevented the United States from turning people away, at least in part. And so the question is, if you're in line, have you arrived? What if the line goes around the block? And apparently, although who knows, that this came up because the United States has adopted a new policy of turning people away. According to the supporter of the law, or I guess the challenger to the United States new policy, that in the past everybody just got in. If you showed up, you got in. You had arrived at the United States. Although there's some question about that because there could be times when they're just overloaded and can't process everyone on that day. So that's the bottom line. What does arrives in the United States mean?
Yeah, it was a new policy, I think, by the 2016 Trump administration that was challenged and was enjoined, and now the current Trump administration isn't enforcing it.
But they
So
want to.
they say they might want to,
Right.
They might, but it's not an issue right now because they just closed the borders, so there's no
No,
reason.
I thought the policy started during the tail end of the Obama administration, and that the problem was that during the Biden administration, they gave up any effort to, quote, meter and say, sorry, our processing facilities are overloaded right now, we can't take anybody else. And instead, they would just simply say, okay, if that's true, then everybody just simply goes into the United States and we'll call you later for processing or whatever. But I think
Briefly on that point, Damien, I think at some point during the argument, the question was posed: how many people do you think got in under the non-metering policy? And the answer was, I don't know, but it's likely in the millions.
Millions, yeah, right. I thought it was, there was a lot of sort of judicial criticism of other members of the bench talking about, well, it's not really people would say either arrives at or arriving at, and more than once there was a comment saying, well, actually the statutory text is arrives in, and I think that's a pretty, at least grammatically, I think that's a pretty significant distinction. But what I found most interesting about that argument was the colloquy between Justice Gorsuch and the counsel for the respondents, the challengers to the policy, talking about what Oliver was just getting at is, okay, the person at the front of the line would qualify, but how far back? And then Justice Gorsuch said, well, that, it doesn't even apply to ports, so what about somebody who's on the banks of the Rio Grande? And then the attorney said, well, actually, the border is in the middle of the And so then he said, well, then what about at the border fence? Well, actually, the fence is actually on our side. So they were, and I thought to myself, I like to hear the because I was just reading the transcript. I'm curious whether.
Oh, it was humorous, definitely.
Okay, very, yeah.
Well, also, and what was it? What if you're climbing the wall?
Yeah.
Right,
When you're straddling.
Yes.
And then she said, well, if the wall were like leaning over or crumbling over onto the Mexican side, then you wouldn't be arriving anymore, or I don't. But it seems to me that the government's going to win this. That at least with respect to the facial challenge, quote unquote, facial challenge that was asserted.
Yeah. Right.
That you, I mean. That it can't be that the person who is a block away from the port of entry is the same. But and that seems like arbitrary line drawing. But then again, the line has to be drawn somewhere.
Now, one thing that came up on that, sort of on that point, is Justice Jackson kept trying to argue that the case is moot and that there's no present case before it. And Justice Barrett seemed to take issue. They went back, not against each other, but they kept using the lawyers to go at each other on that point. So, I thought, frankly, Jackson's argument was pretty good. If the government has no plans to reimpose the policy, then why are they there? Although I think the Solicitor General or whoever the assistant who argued said that. There's a difference on that for standing and for mootness purposes. So
yeah, that was an interesting legal point that I've never really thought about. Like having litigated and briefed many mootness and many standing issues, the idea that as the defendant, you obviously don't need standing, and so whether there is standing in the case at that point is sort of no moment insofar as there is still legal effect of the opinion below on the government, and that's what they are appealing or seeking cert on.
Yeah, in other words, for standing, you must have concrete plans to do something, but for mootness, you don't. The possibility of doing something is enough to keep the case apparently unmoot.
Yeah.
Well, isn't it also true, though, that almost by definition, if you are an appellant, you have standing because, at least for the government, I mean, you're bound by a judgment from the lower court, you know.
Even if the case is moot?
Well, I guess maybe we're talking in a circle, but isn't it precisely not moot because there is continuing legal effect? It may not be important.
I think that's essentially the government's argument. If you want to make say why there is standing for the government here, it's because there's continuing legal effect, and therefore the government is in some sense injured because it's prevented from doing this in the future if it wants to.
Right.
Yeah. So anyway, but it's an interesting point. I think at one point after Barrett had sort of like gone back and forth, as you said, arguing through the lawyer to Jackson, I think Jackson sort of like threw up her hands and said, well, even if it's not technically, we shouldn't take it because there's no concrete plans and it wouldn't be not judicial enough to decide this case. But it's another one that doesn't strike me as needing to be that political. There is a line, and I thought at some point, I think this was Gorsuch again, or maybe it was Kavanaugh. Maybe it was Kavanaugh. I had a nice series of questions about like, well, okay, let's say that we say that this is not the line. Well, then the line will be somewhere else, and then that's where the United States will say we're not going to allow you to come in there. And then if we say that's the line, well, let's keep moving it back at some point. And the response to that was, well, yeah, but they can't keep moving it back into Mexico. And Kevin, I was like, well, they will, because they'll agree to something that ensures their ability to keep people out that they don't want to keep out. They want to keep out.
Go ahead, Damien.
Yeah, I was just say, I think Justice Kavanaugh also had an interesting point that realistically, this is not something that Congress anticipated when it I think the statute's from 1980, because there had never been an issue of being overwhelmed at the border and processing these applications, and that's the reason why the metering policy came out. So,
Well, I was going to say, before you interrupted me, that, no, I'm
I hope your
just-
mother's not gonna say this is another example of our.
Yes, I'm not going to send her this one. She's going to.
Okay, good.
No, I think you did not actually interrupt me this time. What I was going to say is this is a big deal, obviously, for the individuals involved, but it's not a big deal in some sense, as Justice Jackson points out, because the policy is not being, the government's not trying to impose it. But this is another example of Congress's unwillingness to do its job. It seems like if this is truly a problem, Congress could quickly clarify what it means. Because I think there is as you point out, there's a distinction between arrives in and sometimes the lawyers are saying arrives at, but there also was arriving in, which is a little bit different. I think I do agree with that point. And I thought so Congress could clean it up. But I thought the challenger's lawyer did a nice job of explaining the history of why her position is that the people who show up should get in, even if their foot isn't over the border yet. I thought she did a good job on that.
Yeah, I agree, and she has a good point that this is how it was, from the moment it was enacted until 30 years into the future, into 2016, this is how it was enforced. Now, maybe she's got the worst of the precise statutory textual argument, but that history is not nothing.
Yeah.
Let's move on to, there's two other arguments this week. Go through these a little bit quicker. The first was Keithley versus Buddy Ayers Construction Incorporated. Damien, you want to tell us what that one was about?
Well, I can tell you what the case is about. I did not listen to the argument. This is actually a case that I remember we discussed a few sessions ago, that kind of a strange aspect of bankruptcy law, that you have the individual plaintiff who was injured by a truck operated by the defendant trucking company, and he brought a tort claim, but the problem is he also had this parallel personal bankruptcy petition that was pending. And under bankruptcy law, if you have a chosen action for tort damages, that's a potential asset that you have to include. And if you don't include it, then typically in bankruptcy you get penalized for it, because it's like you're defrauding the bankruptcy court.
Yeah.
And so, for apparently innocent reasons, the plaintiff here failed to list this tort action, and as a consequence, the defendant in the tort action said, because he failed to list it in his bankruptcy proceeding, he should be barred from trying to recover against us. And the Fifth Circuit agreed and said that even though it's basically a windfall for the trucking company, nevertheless, that's how it operates, even though there's been no suggestion of bad faith on the part of the plaintiff injured party.
Yeah, I think that's a good summary. The trucking company had absolutely no relation to the bankruptcy proceeding, but nevertheless benefited by getting its case thrown out because of the failure to include this on the form. And it involves a doctrine that, at least per the argument, has only ever been invoked once by the Supreme Court, of judicial estoppel, and that because there is, for lack of a better term, fraud on the court in the bankruptcy proceeding, you're not allowed to proceed in your tort claim in this completely whole and separate proceeding.
But the one Supreme Court case didn't involve bankruptcy, right?
Right. No, it didn't. It was like Maine versus New Hampshire. I think they kept on.
Yeah.
And I didn't read what that case is about, but that was the doctrine that the Supreme Court enunciated in that case in the 1850s. I think it was.
Yeah.
Well, judicial estoppel more broadly is a pretty well established common law doctrine, but it usually just means that parties can't take inconsistent positions in the same case and then try to profit by it. But
In the same case, but this is like separate.
Yeah, I thought it was different than the usual estoppel.
Yeah.
well, since you listened to the argument,
I don't know because as Joshua was alluding to there, in this case obviously there were two separate cases, and and Justice Roberts Chief Justice Roberts got this at the beginning, that there's the goal of this, or one of the goals of this, is for the integrity of the courts and to see that the courts aren't defrauded and issue proper opinions. And so that means it seems to me it's okay, and that this guy brought it up. I'm rambling here a little bit. The argument on the other side is that the company whose driver allegedly caused the accident is getting a windfall. I normally hate that term, like when Liz Warren says that if you have the billionaires getting a windfall because they get to keep their own money. But in this case, I think it's right that the company here is getting a windfall in the sense that it's being relieved of its liability, not because of anything that has to do with the accident or the plaintiff's failure to file within the statute of limitations or something. It's because he supposedly didn't do something that was required in the bankruptcy case, but that is contested. And so anyway, I don't know.
No, I think that the argument from the tortfeasor is that you can't allow these people to commit frauds on the court. You need to just judicially stop them. And because he lied in his bankruptcy proceeding,
maybe
intentional or not,
yeah.
Well, I mean, he definitely omitted the
Yes.
asset. That you should not be able to profit from it in a subsequent proceeding. And I think the Chief's response to that, which was pretty good, is like, well, if we're dealing with like frauds in the judicial system, the idea that this, company that, I don't know what they did. Let's say they ran over somebody with their vehicle, or however they committed this tort, should not be held liable for its acts based on this. Isn't that also calling into question the integrity of the court system? I thought that was a good response. The only other thought I had is now escaping me about this. I guess we'll have to move on.
Well, one thing too is I recall the Fifth Circuit decision. The Fifth Circuit has a particularly strict version of this, that even if there's the appearance of fraud, that basically that's determinative. So you could say that, okay, even if trucking company, we credit your fraud thing, shouldn't we at least remand to allow this poor fellow to establish that it really was an honest mistake?
Yeah.
And if so, then the fraud rationale evaporates, and then there's no estoppel.
Well, that reminded me of the point, the fact that I wanted to make is apparently he told his attorney, and it's the attorney who omitted it from the. And like typically we sort of impugn, or what's the word, we allow whatever the attorney does is impugned into the individual.
Imputed,
not impugn. There you go.
But you can see how that wouldn't work, because if the issue is not so much just simply culpability or responsibility, but rather what was the reason for. I don't think the attorney was doing it to defraud anybody. He just had an honest mistake or whatever.
Maybe. I mean, I don't know. I mean, maybe he was.
Remember, there was in the lower courts, the plaintiff in the bankruptcy. No, the plaintiff in this case, after the judgment was entered, tried to get new evidence in, and submitted the affidavit of a staff attorney for the trustee, maybe, of the bankruptcy, and said that this was not out of the ordinary, that assets can be identified towards the end, just as long as it's done before the final settlement. I have no idea, but that would suggest that intentionally it didn't affect the bankruptcy proceeding.
Not only, right, I think the evidence was that the creditors of the plaintiff would not be would not get anything more,
right?
Even if the plaintiff were to recover in the tort action. So, yeah.
This does feel like a case, as Damien hinted at, where the court's going to reverse and say the Fifth Circuit's rule is too strict, and I'm usually against sort of totality of the circumstances test, but like looking into the intent of the individual and whether he was intending to defraud the court. But it seems like the court is at least going to say, whatever the rule is, it's not what the Fifth Circuit said, and go back and do it again.
Yeah.
The last argument, Flower Foods versus Brock. This case dealt with whether Oliver, you previewed it for us last time, but whether the Federal Arbitration Act covers certain intrastate trips of in the chain of commerce. So Flower Foods, what do they produce? Bread or something?
Yeah,
it's not
Wonder
flour.
Bread.
Yeah.
Wonder Bread.
Wonder Bread, and so they produce it at point A, they ship it into state B, There's so there's some shipment from state A to state B, then there's another trip within state B before it gets to the grocery store. And the question is whether that trip within state B is either part of the original A to C trip or whether it's a wholly intrastate B to C trip. And
And if it's interstate, if the second, so the Brock is the driver who did all of his work within Colorado, picked it up in Colorado, dropped it off at the grocery store or something. And so there's a dispute between him and the company, the Wonder Bread company. And if his trip, the last mile driver they were calling, which isn't totally accurate, but it's good enough, if his trip is included in the interstate commerce, then he's exempt from the Federal Arbitration Act, which for whatever reason. And so the court basically, the dispute, I think, it seemed to come down to the driver's contention was the key is the unloading. Where does the unloading take place? So since at the unloading and loading, so since the driver unloaded and then loaded the goods and then did the same all in one state, that's enough. And the other side, the Flower Foods, seemed to suggest or wanted the test to be the intent of the parties. And since the intent of Flowers Food was to deliver it from out of state to in-state, then everything should be considered interstate.
It's more happenstance that there happens to be an intrastate leg as opposed to
right.
The intent was to ship it from their facilities to the grocery store. Okay, there happened to be an intrastate leg in there, but that really wasn't what we were trying to do here.
Now, now I'm surprised by that. So the defendant company wants it to be considered interstate and therefore does not want.
I'm sorry, maybe it's the other way around.
He's got it the other way around.
Because as I say, because typically you would think that these companies do want the FAA to apply.
They want the, yes, that's right.
Yeah, right. Okay.
Sorry.
Yeah, interesting case. I found the argument very unsatisfying from sort of both. At least the petitioner, I understood the rule. They're outloading and unloading. I don't think the justices were really buying it. It felt like she had a difficult time arguing that from precedent. The justices seem to be more, in my opinion, they seem to be more favorably disposed to the respondent's position here, that this is interstate because of the intent of the shipping. But I found she kept on trying to make her rule sound easy to apply and easily understandable, but I struggled mightily with trying to distinguish and understand where she would draw lines.
Yeah, and the Uber driver was the obvious. If the Wonder Bread comes in from Kansas or wherever, goes to Colorado, and then it's in a grocery store, but then some Uber driver picks it up at the grocery store and drops it off at some guy's house. One of the justices said that's all. Why isn't that all one interstate commerce?
Yeah, I think Alito made a big point. Alito threw up his arms metaphorically. I just don't understand your argument. Obviously, these companies, the final user, which is the phrase they kept using, the final user is always the customer. And her response is, well, they're only selling it to the grocery store. If the grocery store doesn't sell it, they don't really care. They're still getting paid, which on some level is true, I suppose, but it's also they're creating a product so that it is eaten by somebody.
Yeah, and also I think the driver was an independent whatever, some sort of, I think he bought it from Flower Foods and then sold it to the grocery store. So that transaction was still, I think that was a separate,
And apparently in the lower court, there's a lot of discussion about whether title transfers and there's all these other factors, but
which didn't come up in this case. There's a couple. That's one, and I think the contract. There was an issue about contract that also is not present in this case. But there are some other issues bubbling up in the lower courts.
Yeah. So it seems like if I were to predict, I would say that probably be affirmed and kick back down to figure out more details. We'll be back in the court in a couple years.
Yeah.
All right. We also had another, like I said, eventful week at the court. We had three published opinions, two authored, one per curiam. The first is, it was Rico versus something.
United States.
Rico versus United States. This is a Gorsuch opinion, 8-1. This is a case that we definitely talked about on the show when the oral argument came about a individual who, while on parole or supervised release, committed multiple crimes that got her put back into prison. One of her supervised release, the last one, I guess, in the chain, she absconded, committed other crimes while having absconded, including one that is before her supervised release date was ending, and then one that was after her supervised release date. And when she was ultimately arrested, the court sentenced her based on the text of the court's order, based on both the crime that she committed while she was technically still on supervised release and the crime that she committed while her supervised release term had expired. The Ninth Circuit held that because she absconded, her supervised release term was tolled, so the court was correct to consider both crimes, and that was the issue that was petitioned to the court, whether the sentencing court could consider a crime that she committed after the technical term of her supervised release had expired because she had absconded during it. Did I get that right?
Yeah, the term of the supervised release ended in 2021. She disappeared before that, and they couldn't find her. In 2022, she committed a crime. The government finds her again in 2023, and then, as you said, sentences are in part based on the 2022 crime because it was a violation of her supervised release. And Gorsuch said, well, it doesn't really toll. The fact is that you want it extended. So yeah. He said that the statute allows courts to impose a term of supervised release. That term ended 2021. That's it. You can't extend the supervised release beyond that point, even though she disappeared and was otherwise violating the terms of the release.
Yeah, I love, like, he starts out by saying that the Ninth Circuit called this tolling, but it's not tolling, because if it were tolled, then that means that the conditions imposed would also be tolled. They just want to extend the supervised release period. And so it was an 8-1 decision. I think the Alito dissent is worth noting. He says, look, she also committed a crime pre-2021. The court had discretion to sentence her to the exact same sentence that it sentenced her to, notwithstanding the subsequent crime. So it's essentially, there's no error here. Yeah. And Gorsuch, in his opinion, responds to that and says, well, Justice Alito says it's harmless error, but we don't allow them to sentence it for things that they don't have the right to sentence it for. We don't know what the judge would do. And Alito, I love the Alito clapback in his last footnote. He says, I didn't call it harmless error. I said it was no error at all.
Well, in Alito shouldn't worry. I think she'll be back in jail soon.
She doesn't seem to be able to stay away from the authorities. The next opinion that came down was Cox versus Sony. This was a internet service provider. This was a case we also did on the show where the Sony sued Cox, the ISP, because it kept on giving them notices of individual ISPs that were downloading music, copyrighted music, and Cox is like, well, just because we know the ISP doesn't mean we can stop who's ever doing it. For example, like universities was the big example. There are thousands of dorms at a university. How are we going to stop this? What happened, Oliver?
The court said that the Copyright Act does not allow for the extension of the harm. You can't extend the harm to essentially a third party.
Right. They tried to get them on, was not vicarious liability, but some term of liability.
Contributory infringement, was that it?
That sounds right. And the court said there's only two paths towards you either have to show that they induced the infringement, which Sony couldn't do here, or that they were, well, I wrote it down here. providing service tailored to to copyright infringement, and neither of which they could do. Unanimous opinion on the judgment. Justices Sotomayor and Jackson concurred to say, well, that shouldn't be the exclusive list of things that you could be liable for, but they would also include aiding and abetting. But on these facts, you couldn't show aiding and abetting anyway, so we're going to agree with the judgment. Don't have a whole lot to say about this case. It seems like what we expected given the argument, and it would be pretty crazy if you could hold these internet service providers liable for every single individual that copyrights under them. It's noteworthy to say, like, Clement doesn't win them all, right? I thought once again in this argument his presentation was compelling, as it always is, but he got smacked down. The court isn't, got the issue right in my opinion, and notwithstanding Mr. Clement's splendid advocacy,
He still got paid.
I was going to say, yeah, his compensation is, I'm sure, not key to result.
Yeah. Well, Sony was like, I think they got a verdict in this case. This case went to the jury, and they got a verdict for $1 billion.
Wow.
So they had if they had won, they would have been able to play Clement pretty easily.
Yeah, that's right.
There's also a per curiam opinion. This dealt with, let's see if I can get the name right. This came out in the order list. This was Zorn versus Linton. So this is a case that was just granted, and cert was granted, and an opinion was issued, and a per curiam decision dealing with qualified immunity, an issue that we do sometimes litigate here at PLF. This case came out of Vermont or some state in the Northeast, where there was a protest at the Capitol, and the cops were pulling the protesters out of the Capitol building, and one of the protesters got put into an arm lock that she alleges hurt her, and brought a Fourth Amendment claim for excessive force. The First Circuit said this was clearly established that you couldn't use this type of force to remove these protesters. Qualified immunity doesn't attach. The Supreme Court reversed that in a per curiam opinion, saying that qualified immunity attaches. It wasn't clearly established, essentially, not really cutting any new ground other than to once again side with the police officers and give them qualified immunity.
One thing that struck me about this per curiam, other than the fact that it's another per curiam, I think it does show, I think it's the third or fourth one so far this term.
Mm-hmm.
But what I found interesting was that the court was interpreting prior First Circuit precedent. So the Supreme Court was telling the First Circuit that you guys aren't even reading your own precedent correctly.
Right.
And in fact, they ultimately said that, frankly, probably not even absolutely forbidden. We think this is actually probably perfectly okay under the Fourth Amendment, under these or excessive force, whatever it was, for putting somebody in a wrist lock in these circumstances. But that's what I found, because it's one thing for the Supreme Court to say whether our cases clearly establish a rule, but for them to per curiam reversal and say that your own cases you got wrong, I thought that was remarkable.
Yeah. Sotomayor dissent on this one. She wrote the dissent she wrote the concurrence in the Cox case we just talked about. She wrote a dissent in this case, and she wrote another dissent that we're going to talk about briefly. But this was a dissent just to say that the force that was used here was excessive. That's clearly established. We're giving qualified immunity to reflexively to the officers, and we're not doing so when the reverse comes up before the court. Briefly, there's also a related dissent on Villarreal, which was also a qualified immunity case. This was only Sotomayor, but this dealt with, I believe, a woman who was alleging she was unlawfully arrested in Texas after she was like an investigative journalist, and the police arrested her and mocked her when they arrested her, and the officers were granted qualified immunity. I think the Fifth Circuit's opinion, if I remember, was essentially, well, she did violate the law, and so she could have been arrested. There was a valid arrest, in other words. But in any event, qualified immunity was granted. She petitioned the Supreme Court, and Sotomayor says it's another example of reflexively granting qualified immunity, which I am certainly sympathetic to, Justice Sotomayor, so keep doing your business and calling these out. The idea that the government is going to get its immunity for all of these things just as like a matter of course does not seem to be what the Constitution requires. And then lastly, there was a dissental in a case called Reed. I think I'm getting that right. This was, hold on, am I getting it right? Yeah, Rodney Reed versus Gertz. This was a dissental, again by Sotomayor, very prolific this week, joined by Kagan and Jackson. And I'm about to sneeze. Hold on. Where it dealt with DNA and whether the some piece of evidence. Do one of you have it on me? Hold on. All right, fun times. Got to keep it down. I don't remember what the piece of evidence was. Was it a comb or a knife or something that had been handled during the jury, and so the person who was convicted wanted it tested for newly discovered DNA, and it was denied based on the idea that they couldn't show chain of custody. It was contaminated, and I think the prisoner's argument is, well, just test it anyway, and you know, if he has a theory of someone who might also, that blood's there. The court denied that cert petition, and the dissental here says essentially, you know, why not give somebody the opportunity to get DNA tested? It's minimally intrusive and could shed some light. So, any thoughts on any of those dissentals before?
No, let's wrap this thing up.
Well, I just want to check really quick if there have been any orders coming out granting cert. Damien, aren't you awaiting a cert grant today?
I don't think, I think Friday grants are always only when they think they can get the case argued in this term. Otherwise, they don't really have a reason to grant on a Friday afternoon.
If they grant it Monday, they can't get it in this term. Is that what you're saying?
Well, at least that's why oftentimes in January you'll see Friday grants because they want to give the extra couple of days. But anyway, has there been an order?
There have been no additional grants today,
Okay.
So we can move on to our final event of our Supreme Court show today, and this is the Oliver special.
Jose Ramirez.
Oliver, what year were you born?
What?
1971, 1972?
73.
73, all right. Well,
I don't know why that's relevant.
we're going to name every justice who served from 1970 until 1990. So when Oliver was in high school and graduated high school. So no justices, so they had to have served during that period. They could have served before that period, and they could have served after that period, but from 1970 to 1990, those 20 years, there are 13 justices.
That's it?
That's it.
Blackman.
All right, 1. Damien.
Berger.
Yes.
Powell.
Yes.
Stewart.
Potter Stewart. Yeah.
Rehnquist.
Sure.
Marshall.
Thurgood.
Kennedy.
Tony.
Douglas.
William O. Douglas. Yeah.
Scalia.
Scalia.
White.
White.
How many is that?
I think you're at about 10. Yeah, we're missing 1, 2,
10.
3, I think.
3 to go.
3 to go.
Oh, Sandra Day O'Connor.
There you go.
Brennan.
Brennan, good. I thought you missed that. I think you got one more to go.
Do you know, Damien?
Well, it's your turn, so if you can't get it.
I know, but I'm,
Yeah.
I think Thomas was after that, right? That's
Yeah,
what I'm
he
trying
was
to,
after it. I will, should I give you a nominated by? Or should I just give it to Damien?
Well, I don't care.
You got it, Damien?
Goldberg.
No. Nominated by Nixon. Or no, scratch that. Nominated to the Circuit Court by Nixon, nominated to the
John
Supreme
Paul
Court.
Stevens.
John Paul Stevens. Yes.
Stevens. Mm-hmm.
Yeah. That's pretty
Wait,
good,
is-
I thought.
Wait, Stevens from, are he and Blackman the Minnesota Twins?
No, Berger. Blackman and Berger.
Berger.
Yeah, Stevens was from Illinois, I think.
Oh, that's right, okay.
I think we should give ourselves a pat on the back. That was
Pretty good. 12 out of 13. Pretty good.
Yeah.
Do you know when Brennan retired, the clerks or somebody put a bunch of his opinions out in like a hallway, and they had a reception, and Scalia started walking down and looking at him. He says, "Bill, you got a lot to make up for here," or something like that.
That's pretty good.
That's great.
All right. Well, guys, thank you for joining me. Happy Friday, and go Brewers.
Go Guards.
Guardians, Padres. And we'll catch you next week.
All right, thanks.
Thanks all
See
for
you.
joining us.